SJC-13768, Commonwealth versus Richard Arnold Sr.
Okay, Attorney McKenna, whenever you're ready.
May it please the court. James McKenna for Mr. Arnold. Good morning. Much of our claim concerns the idea that it was unreasonable back in 2012 for the Superior Court to order a 10-year imposition of a warrantless search. And that order itself was unreasonable on several grounds, one of which was it presumed that all the treatment, all the counseling would fail. It also relieved the government of its burden to establish a demonstrable risk as the years of probation went past. That burden was relieved by that order. We would suggest improperly. We'd also suggest that it was unreasonable in 2024 for the court to order effectively a 7-year warrantless search. And on that basis, the unreasonableness would be the same as the original unreasonableness. As the court knows, as we referenced in the 16L letter, the appeals court has spoken on this recently, has spoken about how there should be a determination by the court as to whether the duration is proper on an individualized basis. In their brilliant brief, we have some of the authors of that brief here today, CPCS spoke about how this should be done every 3 years. And I would suggest that 3 years perhaps would be the maximum. If there's an individualized consideration by a superior court as to the duration, that could be in 1 year.
Can you address, as far as it goes with this case, and the reason why the Judge White, the second judge, looked at this? If you look at the impact letters by the two siblings, would the 10-year be reasonable given the impact? Because they're very strong letters.
Very strong letters.
Right. And would the 10 years be reasonable given the trauma these kids have suffered? They have had childhood stolen. And I assume if you went to the male victims and you said to him, what about 10 years? He'd say, are you crazy? He'd say the same thing he said before. So wouldn't, and I know the judge didn't look at the 10-year, and nor was a requirement as far as duration in front of Judge White, but couldn't it be reasonable given, in this case, the reason for the exclusionary zones?
Your Honor, to begin the answer, the acts of my client were terrible and terribly damaging. And in that situation, it was entirely understandable that those letters came in as they did. As noted in the CPCS brief, there is a 5-year limitation on probation itself on the U.S. sentencing guidelines.
Yeah, but there's no, that's not our law, but go on.
Yes, Your Honor. This is just goes to what might apply in terms of reasonableness. Sure. If there had been a calculation, I would suggest that 3 years would be the appropriate time by Judge White last year as the maximum. Come back in 3 years. If things are as they are now, we'll order another 3 years.
So we'd go back to the two siblings and say, every 3 years, do you still want him stayed away from you?
And the answer would be pretty clear. They could.
Right.
Yes.
So I'm just wondering, essentially, is a remand an exercise in futility? That's my bottom line.
It could be, but Your Honor, I would suggest that Judge White could say, let's say 5 years, let's say 3 years, let's say a different time. As the Streed case spoke of, there should be a determination based upon, even given the allowance of the GPS monitoring of the warrantless search, there should be a determination as to what's appropriate in a given situation. There may be situations where it's appropriate to order a lengthy term of probation with GPS, and there may be ones where it's not. And that determination would be something which would fall into what the court deems to be reasonable. I was just 3 years. Yes, Your Honor.
Can you just be more precise about this 3-year idea? Is it really your proposal that a defendant would receive a sentence of 3 years of GPS monitoring, and then with no probation violation, no GPS violations, the defendant has complied with those 3 years, the judge would 3 years in decide whether to give a further 3 years?
Or it could be a 10-year sentence of probation with GPS and to be evaluated at 3 years, as of no more than 10.
Those are materially different, right? Being given a sentence of 10 years of GPS monitoring with the potential for it to be reduced after 3 years is a much more severe sentence, is it not, than a sentence of 3 years of GPS monitoring with, and then potentially the addition. Don't those seem different to you?
Absolutely, yes, Your Honor.
So what precisely, if you were going to write on the, on the order, what are you suggesting that order should say?
That the Commonwealth, after 3 years, must sustain its burden of proof relative to the reasonableness.
So the sentence would be probation for 10 years, GPS monitoring for 10 years to be revisited in 3?
Every 3. Yes,
Because a sentence of 3 years probation, and then we'll do it again, would have double jeopardy components to it, wouldn't it?
yes, Your Honor. Yes, Your Honor. And someone would be back before you discussing that exact concern. But if there were a requirement the government established every 3 years or every 2 years or every year, depending upon the nature of the case, it might be every 3 years or it could be every 2 or 1, depending on the nature of the circumstance.
Isn't that also present a little bit of a double jeopardy concern, because the defendant then is having to go through it's not the guilt has already been determined, but are there any other context where you're familiar with that occurring?
It could be like a Felice hearing as required by Rodriguez to take place immediately, essentially. And this would take place every 2, 3, 4, 5, whatever the court deems appropriate number of years. I would suggest 3, but it's my understanding you guys.
Is that your understanding of what the appeals court decision was in Street? That there would be a 10-year, let's say, a 10-year probationary period with GPS monitoring for 10 years to be revisited in some period? Or was the appeals court instead saying, you have to determine now, dear judge, how long GPS is going to be instituted, and that's it?
The latter, Your Honor. And it would.
So this would be a departure from the appeals court's decision?
Yes, Your Honor.
And consistent with Felice et al., shouldn't we be saying to judges, this is a big deal, this is a search, a warrantless search, before you go beyond a few years? You better be darn careful and have a grounds to go beyond a few years. And so you don't have these double jeopardy issues. You just do it at the time of imposition, with the caveat, you're really treading on dangerous constitutional waters if you get out to 10 years.
Exactly, Your Honor. And this would be something the government would need to carry its burden of establishing.
Oh, absolutely.
Yeah.
But the facts here, it's hard to imagine sort of more traumatizing facts, right? So, every time you do this, if you have this sort of 3-year revisit, you're going to re-traumatize the victims because they're going to have to come to terms with this again. They can't just ignore it. So I'm just trying to understand, in these specific facts, with these traumatized, now adult children, isn't this reasonable? I just, because the alternatives you're talking about are going to re-traumatize them every time you do this.
Yes, Your Honor, which is why I did not suggest 1 year, because it would be traumatic every year. And 3 years might be appropriate in that context. It would be like a SORB hearing every 3 years.
Just to Justice Gaziano's original question, though, I mean, we know what they're going to say 3 years from now. And they're not interacting with each other, so there's nothing going to change that's going to make them feel any better. I'm just trying to get a sense of what the purpose will be.
In cases like this, it would be perhaps different than in other cases where there wouldn't be victims this traumatized. And from that perspective, a rule set by this court as to how often it must come back, or even sooner than that, as appropriate, depending on the nature of the case, as in Street, where it's just sent back to the appeals, to the trial court judge to make that determination. How long should this be? There could be a maximum number, 3, perhaps 5 years, some number like that, whereby it must be addressed the government must carry its burden in that time frame, at some point in that time frame.
Are there any other factors that you think would change in the 3 years? You seem to be conceding that it's unlikely that the victim's position would be changing.
They could move out of state. They could do something along those lines. Originally, this is a case where there's a level 3 circumstance, and that itself, as this court spoke of in Roderick, would be enough if there were exclusion zones. If we were to discuss the particulars of this case, there was a order on, I believe it's page 72 of the record appendix, a discussion by the Judge White about how the exclusion zones tipped it in terms of requiring GPS monitoring. It's not entirely clear, but that's my take on what he says on page 72.
What's the status of the exclusion zones currently? Is your client, has he been informed of them? Have they been set?
That's the thing, Your Honor. They have not been set. And so he's gone more than 4 years with no issues and no exclusion zones. And that itself goes to what's reasonable here. The Commonwealth has very reasonably suggested that there be a remand relative to setting up the exclusion zones. That could be deemed distinct from exclusion zones and GPS. Because if he's done well for 4 years with no exclusion zones, perhaps there's no need for an exclusion.
But didn't Judge White specifically say if there's an issue with the exclusion zones, come back on June 28th? I think the sentencing was earlier, or the hearing was earlier that same month. And so if the defendant understandably wanted notice of where he was excluded from, shouldn't he have gone back?
He should have. I don't think they've been set. Counsel for the Commonwealth may know better, but I believe the Commonwealth's brief spoke about how they had not yet been set. And the burden should not be on Mr. Arnold to come back and say, please set up the exclusion zones.
So you're not contending that Mr. Arnold right now is in a situation where he's walking around the Commonwealth and he doesn't know where he will get in trouble for being. I thought you were arguing that, but you're not arguing that, because if there are no exclusion zones, he's not going to be in trouble for going anywhere.
Exactly, Your Honor. Exactly. And this is the case where in March of 2024, the Commonwealth almost conceded that it would be appropriate to withdraw the GPS monitor. On page 12 of that transcript, the Commonwealth said, we can't find the victims, there's no problem, there's no exclusion zones.
But then you talk to the victims, and the victims are super traumatized, so then the Commonwealth responds to that, right?
Absolutely, yes, Your Honor. Absolutely, yes. And in the May hearing, the judge finds that it was appropriate. But he does find that the existence of exclusion zones tips it. But to Your Honor's point, there are no exclusion zones. So perhaps it could be deemed, if this court were to make a determination as to whether it's appropriate at all, it would tip the other way, given the lack of exclusion zones.
But we can still follow where he is, right? I mean, that's the point. Can I ask a question about, are you conceding in this case where the victims, it wouldn't make sense to ask them to come back every 3 years? So in a case like this, something could be fashioned so that unless they have moved away, they shouldn't have to come back and say why. And the record would be clear about why they would continue the GPS.
Yes, Your Honor. That would make a great deal of sense to fashion something along those lines, where their position was stated and they weren't re-traumatized on a regular basis. Yeah, absolutely, yes, Your Honor. Unless the court has any further questions, I'll rest on Attorney Coben's brief. Thank you, Your Honor.
Thank you.
Good morning, Your Honors.
Attorney Kidd.
My name is Rob Kidd. I represent the Commonwealth in this matter from Bristol County. I wanted to start with the very last issue first, which is kind of an administrative issue, but it's important for the victims. Obviously, the victims would be concerned about their addresses being known by the defendant. And what happened is the defendant, in his original argument to the court and brief, said that his client didn't know what the exclusions were. He said that there were exclusion zones, but his client could be just driving down the highway and all of a sudden.
How do you set an exclusion zone without notifying the defendant?
Correct. And so.
You can't have both ways.
Right. So, but the upshot is that just to let the court know, there are exclusion zones and the defendant does know of them. I'm just letting the court know. I know it's a new piece of information, and that's a peace of mind. I understand it's. I think it's a radius, as the court knows, so the defendant would not know the addresses.
Do you agree that setting probation for 10 years and exclusion zones and GPS is extraordinary and should only be done in extraordinary circumstances?
No, I think it's Your Honor alluded to it before, but I think it has to be evaluated on a case-by-case basis. This is a fairly extraordinary case. This is sexual abuse of children involving terrible allegations of anal rape, oral rape over 6-7 years. This is a level 3 sex offender who the Sex Offender Registry Board has determined that means he has a high risk of reoffending. These are contact offenses with children. So, and we have victims who, as the court knows, appeared in court as the victims did in the Rodriguez case and expressed their fear of the defendant, and the court in Rodriguez took that into consideration. I think under all those circumstances, I think that this could be viewed as within the range of reasonable alternatives in this particular situation. That being said, Your Honors, obviously that Street case came down after I had written and submitted my brief. It seems to have maybe changed the landscape. Maybe that's why we are up here. What I haven't seen confronted in the case law and with all the cases, which is Feliz, then it's Rodriguez, and then Rodriguez, and then Rodriguez, and then Street, those 3 cases, is the statute, the actual language of the statute, and I did reference it in my brief. The statute is very clear that when the judge orders probation under Section 48, the probation shall be for the entire term, the GPS monitoring shall be for the entire term of probation. And I never really saw that addressed in the case law. There is some talk, I think, in Rodriguez, Rodriguez, I think.
Is that the statute we struck down?
What's that?
Is that the statute we struck down in Feliz?
I don't know that it's any different. It may have been struck down. I don't know if there was any different. Well, I didn't think the statute was actually struck down. My understanding of Feliz was that the corporate, it was a...
Well, it was struck down to the extent that it was automatic.
Right.
Yes, monitoring. That was
right.
Feliz.
So maybe that's a moot point. But in any case, the Commonwealth is not necessarily, opposed to having these cases, having a specific, adding to the considerations of the trial judge the time of probation, the time of monitoring, so that it could be remanded and the trial judge could determine.
Those are 2 separate things, though, just to clarify, the length of probation and the length of GPS monitoring.
Correct.
Right. So one could have a 10-year probation period with all sorts of conditions, but the GPS might be a different time frame.
That could be the case. Again, I was reading the statute wrong. My understanding, again, I'm going back to that, but my understanding was that there would have to be concurrent, but they would have to be the same, actually, under the statute.
Counsel, my concern with these always is, how is this practically going to work? Okay, so when we were questioning the appellant, we were talking about the reasonableness of the duration. Okay, so assume for the sake of argument that the appeals court got it right and there's got to be an individualized assessment of the length. How is this going to work? Because trial judges struggle with this all the time. Is it the condition that's causing the behavior to be compliant? And so if we had a return every 3 years, and with the Commonwealth under Rodriguez having the burden and saying, okay, the defense is going to come in and say, nothing's happened in 3 years. Why do we need to extend the GPS anymore? And this is the age-old probation conundrum. So how is this going to work at the beginning if the judge is going to say, we need 10 years, and the defense says, we don't need 10 years? How are we going to gauge this in between? Because you could always make the argument that, okay, nothing's happened, and then the Commonwealth goes back and toggles and say, well, nothing's happened because we've got a GPS.
Correct. And things, I understand that. It's a question that the court's grappling with. I mean, things can change. There's the SORB classification that can change. For example, this defendant's a level 3. So I suppose that's a good indicator of a good guide for a judge, perhaps, to reconsider the GPS monitoring.
Well, that's one of the issues in this case, right? About the SORB classification, whether the judge can consider that. But none of these things are weighted any differently than the other. So I guess I'm looking to the victims came in this case. Not only did they give victim witness impact statements, but they went and got a restraining order, right? So, you know, if all things being equal and the compliant with treatment and the classification drops, and again, the victims come in and they say, well, I'm still terrified. Understandably, I'm still terrified. Again, I'm just wondering, how is this going to work?
I think judges do that already. They make determinations based on, you know, changed circumstances. And I think I can't say that the defendant in this case is not wrong, and that these victims in this case understandably would probably want this person to be on GPS monitoring forever. And I can understand that. I would want that same thing. So that's one of those things that the judge could consider, but that's only one of those factors. One of those factors that the judge could consider. So he would have to go through those, you know, the factors in Felice, you know, the severity of the offense, the contact or not contact, you know, the SORB classification, has that changed? I know that there's some studies that talk about the age of the defendant is relevant to that determination. So those are all things that I think the judge would have to review. I mean, so yeah, this is an issue, as I said, that obviously came up after we briefed the case, and it sounds like the court is going in the direction of the reasoning that the Commonwealth has to continually justify a search.
Well, I mean, it's the Constitution. It's not.
No, I understand that, Your Honor. I didn't mean to misspeak. It's the burden does increase as the defendant is on the bracelet. I understand that. The bracelet can go off and.
Sorry, would you agree that at no point in the proceedings below does it appear the judge considered the duration of the GPS, of the imposition of GPS as a factor?
You certainly didn't specifically reference that.
And would you also agree that the duration should at least be considered?
Yes.
All right, so I guess that would lead me to ask, do you then agree that a remand would be appropriate to allow the judge to do that?
I think that would be appropriate.
Is it not only appropriate but required?
Under Street, it is, yes. Under Street makes it very clear that the judge has to consider that. So if the court is in agreement with Street, certainly.
I wouldn't wonder what the Commonwealth's position would be.
I think our position is yes, that should be a consideration.
You agree with the appeals court?
I agree that the time factor is a consideration. Yes, yes.
If this weren't GPS, and this is a question born of my own ignorance, if this weren't GPS but some other condition of probation and circumstances change such that I suppose it would always be the defendant, sought a modification of the terms of probation in order to have that condition modified. What's the mechanical process for that? What's the procedure for that?
I think there would be the defense's burden to file a motion to bring the case back to the court and modify the terms of probation. That would be the mechanism for that. Okay, so do you have a view on whether that mechanism could be used if instead of having like a automatic term revisitation, a defendant could use the existing procedure to come back and question or ask the judge to modify the duration of a GPS? I think it makes some sense, and I've thought of that, and I think the defendant and his attorney would be in the best position to know whether or not the defendant has been complying and so forth, and when to bring it before the court. I guess the
Doesn't that
problem with,
shift the burden to the defendant?
that's the problem with the reasoning in Street is that it implies that the Commonwealth has to initiate this itself. But I think as a practical matter, I think the defendant himself is in the best position to know.
But given that GPS is a search and the government needs to justify the search, it seems to me that putting the onus on the defendant to say, hey, I don't need GPS anymore, is contrary to what the Constitution requires.
Well, I think the defendant, well, that's what Street tells us. I don't know that it would be improper to ask the defendant to bring the case forward.
Well, I think Street talks about it, the imposition of it. But like any changed circumstance in the conditions, that wouldn't change who has the burden. Because if the defendant says, hey, you know, at the beginning of the assessment, the judge says 5 years, and then 2.5 years into it, the probationer says, I don't think we need 5 years anymore. I don't think that necessarily is inconsistent.
Yes.
Aren't you familiar with probation terms where a judge would say you have 5 years of probation, but come back in year 2 and we'll rethink it?
Yes. Yes.
That happens all the time as well, right?
Yes. Yes. But again, I'm playing devil's advocate for myself. I know that the Street seems to take the other position.
We're not controlled by Street. So.
And I take it that the SORB classification, in your view, is to be given weight, but you're not arguing that it's dispositive on the question of whether to impose GPS monitoring or for how long?
No, it's not dispositive. It's one of the factors. I think it's a significant factor because there's an individual determination at the SORB hearing with where the hearing officer takes into consideration all those biological factors of the defendant and so forth. And the static 99 is employed, so it's an important tool. It's an important tool in the toolkit. I don't have anything further. If there are no further questions, it's been a pleasure. Thank you, Your Honors.